AI copyright lawsuits dominate the headlines, but the real legal battle is happening behind the scenes. From synthetic performers and AI training rights to virtual production, data localization, and digital ownership, media and technology contracts are being pushed to their breaking point. Discover the 6 hidden legal pressure points reshaping entertainment, gaming, streaming, and AI, and why tomorrow's winners are designing for compatibility, not just compliance. Most AI debates focus on content generation, but the larger challenge is now enforcement. Contracts, platform rules, and operational systems are struggling to keep pace with AI-enabled media ecosystems. Agreements drafted only a few years ago often lack provisions for AI training, synthetic performers, and cross-platform data use. Those omissions are becoming major negotiation points today. Game publishers now produce film and television content, while streaming services increasingly resemble gaming platforms. AI touches nearly every layer of content creation, distribution, and monetization. Intellectual property now travels simultaneously across games, film, streaming, merchandising, social media, and AI systems. Traditional licensing structures were never designed for this level of interconnectedness. The greatest legal threat is no longer isolated infringement. It is the collision between outdated contracts, conflicting legal systems, platform incentives, and rapidly evolving technologies. Because courts and regulators have not provided definitive answers, sophisticated organizations are adopting adaptable licensing and compliance structures. Flexibility is becoming a strategic asset. AI-generated voices and performances are forcing companies to rethink traditional talent agreements. Many older contracts never contemplated synthetic replication or AI training rights. Cases involving voice imitation established important publicity rights principles long before generative AI existed. Today, those precedents are being tested in entirely new technological contexts. Common law and civil law jurisdictions often approach performance rights differently. Moral rights protections in countries like France and Japan can create additional restrictions on AI-generated uses. Studios often prefer not to revisit older agreements because renegotiation is costly and disruptive. As AI monetization expands, those legacy rights become increasingly contested. If you're interested in AI law, digital media, gaming, Web3, and emerging technology regulation, take a moment to like this video, subscribe to the Gamma Law YouTube channel, and turn on notifications. We publish regular legal insights designed to help businesses stay ahead of rapidly changing technology landscapes. Streaming adaptations frequently drive increased game engagement and spending. Yet most contracts provide no mechanism for allocating value created across multiple platforms. Game companies, streaming services, and distributors each control only part of the user journey. Without complete visibility, determining revenue attribution becomes extremely difficult. Developers increasingly promise that AI models are trained only on authorized datasets. Verifying those claims, however, remains extraordinarily difficult. Promises regarding training data often function more as risk allocation tools than true guarantees. Proving a model is completely free from contamination remains a significant challenge. Consumers often believe they own digital products they purchase. Legally, many of those transactions are structured as licenses that can be modified or revoked. Courts continue to struggle with applying traditional ownership principles to digital assets. The outcome could reshape resale markets and platform business models. Interactive media increasingly depends on globally distributed infrastructure. Compliance obligations become more complex as data crosses multiple jurisdictions. Regulators generally do not excuse compliance failures simply because multiple vendors or systems are involved. A single breach can create exposure across numerous regions. Film and television productions now rely heavily on game engine technology. This creates overlapping questions involving software licenses, production agreements, and IP ownership. The future challenge is not merely following regulations. Organizations must align contracts, technology, governance, and operational workflows in ways that remain sustainable as laws evolve. Need guidance on AI licensing, synthetic performer rights, platform agreements, digital media contracts, or cross-border technology transactions? Visit gammalaw.com/contact and speak with the Gamma Law team. Click the suggested playlist on your screen and continue exploring the legal issues shaping the future of technology.